Good afternoon. I want to welcome everybody to the beginning of the 2011 CAP seminars. Some beginning stuff first. First, I want to introduce to you the president of the Wayne County Criminal Advocacy Program Board, Judge Michael Hathaway, who would like to make some statements before we start.
All right, well, welcome back, and it's good to see all of you. Just a couple of reminders about our policies and procedures here, especially for those of you that are new to the program, but also for those of you returning again. Our seminars are on Friday afternoons, more or less 10 in a row, until the 1st of December, with a couple of Fridays off. Look at your schedules carefully to make sure you know when you want to be here and when you don't. For those of you with 10 or more years of practice, you must attend 4 seminars. For those of you that with less than 10 years, you must attend 6. There are going to be video recorded repeats of these seminars shown in the jury assembly room at the Frank Murphy Hall of Justice beginning in January. You are permitted to attend 2 of those as make-up sessions, but not more than 2 video. And that schedule will be posted later in the year. These seminars are scheduled to begin at 1:30. They don't usually get underway until about 1:45, which gives you a little bit of wiggle room. And I know many of you can get tied up in court arguing motions or conducting hearings and so on, but we do want you to be here by no later than 1:45. And if you cannot be here by 1:45, then this isn't going to count as a seminar for credit for you, because my assistant Alicia is out there on the front desk monitoring all of your entrances and exits, and she'll be handing out evaluation forms as you come in. And if you get here much after 1:45, you're not going to get a form and you won't get credit for attending. Then on your way out, you will submit your form to Alicia, and that is how you get credit for attending the seminar. And you must wait until the seminar is over before you leave and submit your form. And a couple of ground rules while you're here. We use this auditorium at the sufferance of the Wayne County Building Authority. They do not want us to drink or eat in this room, so please do not bring drinks or food into the auditorium. And while you're here, we do expect that you will be attentive to the proceedings, so no cell phones, no cell phone conversations. And if you want to read War and Peace rather than listen to the seminar, you're certainly welcome to do that, but you won't get credit for the seminar. And we do, from time to time, monitor the hallway to make sure that you're not talking to your railroad merger clients while you're supposed to be paying attention to the seminar. So, I don't particularly relish or enjoy the role of middle school assistant principal, but I find that I sort of have to adopt that persona in making sure that we assure that everybody who attends the seminar gets full benefit from it and isn't disturbed or interrupted during the course of the seminar. All right. I also wanted to remind you that there is going to be a reception at the A-Bar in the Athenaeum Hotel immediately following today's seminar. I understand there are adult beverages involved in this reception, so you're warmly invited by the Wayne County Criminal Bar Association to attend the reception at the A-Bar immediately after today's seminar. Anything else?
That's it. I'll talk about Susan now.
Okay. I think Mr. Clark has a few additional thoughts for you. Have fun. We'll see you.
First off, I apologize. I am not Tom Loeb. My name is Keith Clark with the Wayne County Prosecutor's Office, formerly a member and president of the Wayne County Criminal Defense Bar Association. Mr. Loeb is in federal court and was unable to be here today. That's why I'm here today. I want to make a couple of quick announcements. There are 3 forms out front. To explain them to those people who don't understand, The first one is your attendance, your feedback form for the seminar. This is what you need to pick up and turn in for credit for the seminar. There's two other forms out front as well. One is an application packet. If you're new to practice here in Wayne County and you are not currently on the list to receive assigned cases in Wayne County, there is a form or an application packet to fill out. That is for the circuit court. That will be reviewed by the assigned counsel committee for your ability to receive the assigned cases here in Wayne County. In order to receive the assigned criminal cases in Wayne County, you must be a member of the Wayne County Criminal Defense Bar Association, and you must be an active member and had paid your dues. I've talked to Ms. Reed. She's here today collecting the checks. They sent out a bunch of recent emails saying that you may or may not have paid your dues. Ignore that. There's a computer snafu. If you've paid your dues, we know who you are, and we will make sure the information is corrected. There is a list out front if you want to make sure who is active in their dues or not as to who has paid their dues. Also, a requirement to receive assignments in Wayne County is you must have an office in Wayne County or reside in Wayne County. Those are the requirements here in Wayne County that was ordered on and ruled on by the board. Now that that business is out of the way, we're going to talk today about the new changes to the Michigan Sex Offender Registration Act. We have one main speaker and one very short speaker. To introduce our main speaker today, I would like to introduce an attorney, Mr. Matt Carpenter. Come on up, Mac, who has been practicing here in Wayne County for at least the 20 years I've been down here. So, Mr. Carpenter.
Thank you very much. Thank you very much. I'm very, very excited to introduce my daughter as the keynote speaker here today. Rather than tell you about her accomplishments and education and publications, etc., you can look all that up on her email. I mean, on her website on the net. I would like to tell you what I've learned very briefly from my daughter since, well, actually starting the time she was in high school. She worked in my office during the summer, my law office. She would answer the phone, do some filing, and do some proofreading, because I was a terrible speller, and she'd do proofreading on my motions and sentencing memorandums. Late one morning, I got back from court, and Cheryl was on the phone. So I waited. I just waved, and I waited, and about an hour passed, and she's still on the phone. I figured, well, she's talking to a girlfriend with problems, or maybe her boyfriend. So I didn't do anything, interrupt her, and I went to lunch. I came back, and she's still on the phone. So finally she gets off the phone, and I say, Cheryl, who were you talking to that long? Because I was kind of irritated, thinking, you know, she's not doing my work. And she said, oh, that was your client's mother who had the sentencing this week. And I had just read she told me she had just read the sentencing memorandum I prepared, and she said, Dad, that's not adequate. That's not even adequate, much less a very good sentencing memorandum. You don't have anything except his name, date of birth, address, and where he works. You're not telling the judge anything about him. And this is coming from a high school student. So she had taken 5 pages of notes from the mother to get the complete family history, which of course I had, I kind of reluctantly incorporated this into the sentencing memorandum. And I believe it was for Judge Jackson, but I'm not sure. And the judge was blown away by the completeness of my sentencing memorandum and said this changed his potential sentence from prison to local time in jail. So I learned that valuable lesson that you have to get to know your clients. There's no detail that's unimportant. Know everything you can, because eventually you're going to have to tell your client's story, either to the judge if you take a plea or to a jury if you go to trial. Because what the juries and the judges want to hear is a complete story about your client, and the only way you can get that is by listening and interviewing your client completely. And this is how Cheryl practices today. She is extremely thorough. She's heavy on motion. She's very successful in her motion practice. And she taught me when she started practicing here in Wayne County about 10 years ago after 5 years in St. Louis as a criminal defense attorney. Dad, motions are the most important things you do. I said, why is that, Cheryl? She said, it tells the prosecutor, the judge, and your client also that you know more about this case than anyone. You know more about the law applicable to this case. Even if you're unsuccessful in your motion, you're sending a message to everyone that's important to your case that you're on top of this case, and it will pay off. So I strongly urge you, as my daughter urged me, file a motion, even if it's a motion just in limine, which you're going to take for granted, to exclude certain evidence. Show that you're ready for whatever's coming, whether it be a trial, a plea, or a sentencing. And this is what my daughter has taught me. Be complete. Be very thorough. Do your work. It'll pay off for your client, and you'll have the satisfaction of doing a real thorough and professional job. And with that, I'd like to introduce my daughter, who I'm very proud to introduce, Cheryl Carpenter.
That's the first time my father has ever introduced me, and I have to admit, I don't remember that story, Dad. I remember getting on you about collecting. He'd have all these files where he wasn't collecting the fees. That's what I remember. But you know what? It is so true. Get to know your clients. Get to know their story. And it's especially true with the Sex Offender Registration Act. Because if any, can I see a raise of hands of who has ever done a motion to remove somebody from the sex offender registry? See some, a few. How about a CSE case? Got a lot more. And we all know we walk into courtroom with the most hated person on the planet. It's the worst crime, in my opinion, to be charged with. Nobody is sympathetic. Everybody looks at your client like they're guilty. There's no presumption of innocence. So you have to tell their story and get to know them. And you do that in these removals from the Sex Offender Registration Act. You've got to get to know them. And what I have learned from getting to know my clients, that being on the Sex Offender Registry is a horrible, horrible way to live your life. I had a mother crying to me saying, I don't want my son, who had teenage sex, to die as a sex offender. I don't want him to get buried with that label and that stigma still on him. I had clients telling me, I'm a shell of a person. I'm not the same person as I was before. They say, I'd rather be in prison because this is like an invisible prison I'm living in. I'd rather have a murder conviction. They're desperate. I've had many clients attempt suicide. So I'm here today to give you all the tools to help these people, because there's a lot of them out there. And please, if they call you, I'm getting so many calls and I can't help some of them, just spend 10 minutes listening to their story, because that will really make a difference in their lives, even if you can't do anything for them. In Michigan, we have the second highest number of sex offender registrants in the country per capita. We have over 46,000 sex offenders on our registry. This is more than Ohio, Indiana, and Pennsylvania combined. And the reason for this is because before the amendments in July of this year, we were over-inclusive. Our registry included everybody. We had juveniles on the list. I had a person call me and said they were 9 years old when they were put on the registry. 9-year-old. And they're deeming that person as a predator. We had HIDA put on the registry before 2004. We had expungements, which are still on the registry. And with the new amendments, which were part of the Adam Walsh Act, there is some relief. Also, I want to point out that it's important when you go and argue these motions to know the legislative intent, because it really helps persuade a judge. And you can find it in 2.172A. It's right in the beginning of the Sex Offender Act. It says, the legislative intent of the registry is to prevent and protect against the commission of future criminal acts by convicted sex offenders, because they think they pose a